It is March 10th, 2026, and this is the Court Gallery. Welcome back, ladies and gentlemen. Today, we're starting things off in Judge Simpson's court where Choate has disappeared. She's vanished. Ladies and gentlemen, she has taken the money and run. And we're going to see exactly what happened in court today with all the players with the 401k and all that type of good stuff. Then we're going to go hang out with Judge Allen for a while. Not Mr. Allen, Judge Allen, where he has a long heart-to-heart with a young lady who has some serious issues to work through. Then we're going to spend some time with Judge Middleton. And man, he's being Middleton all day long. For more information about these cases, check out the description. We're finally finishing things off with one of the craziest divorces I've ever seen. And it all starts right now.
Court does call the case. Fixing Housing 401k plan versus Erica and Aaron Ward. Counsel, state your appearances.
Wayne Valdez on behalf of the plaintiff.
Erica, Aaron Ward, defense.
All right. I think, counsel, did I not have from you a motion to withdraw?
Your Honor.
Pardon?
Yeah.
Okay. I also have, and I don't know whether or not you were served with them because I'm not clear what entirely what Ms. Tope is doing. But did you receive from Ms. Tope a motion to remove and expunge the court's order?
Got an email copy of it that I'm aware of, yes.
Okay, so you...
I don't know the result of it though.
Well, first of all, I can tell you part of the result of it is that she marked it an emergency. I did not deem it an emergency. So I set it for hearing today along with the other motions. Okay, that was the resolution. The reason did you folks receive a copy of that?
Not sure what you're referring to. I don't know anything about it.
Donna Tope's motion to remove and expunge the court's order for contempt. Okay.
I don't know. I didn't think I was
not received. You got an email copy. All right. So then we received, and I guess I'll deal with that one first, if you don't mind. We received then a communication from Ms. Tope that she was unavailable for her own motion today. So that motion, Donna Tope's motion, will be adjourned. And I'm not changing anything. The bench warrant is still outstanding. So my next day.
March or April 14th.
14th?
Yeah.
I'm a little busy that day. March 17th, 2026, 9 a.m. So that I'll adjourn the Donna Tope's motions. Counsel, I'll leave it to you, given your motion to withdraw, as to whether or not you want me to finish ruling on the other motions or hear your motion to withdraw.
It's my understanding the last hearing you ruled or granted liability or the motion to stop the motion, and we're here today for a hearing on damages, which I suspect we're prepared to move forward with that that might result to the conclusion of this matter, which might make my motion to withdraw moot to a certain extent, and also make the defendants, we're calling it the second omnibus motion, might make it
Pardon?
moot as well.
Oh, yes. All right. Folks, what do you have to say to me on the issue of damages?
So the issue on damages, okay, so the thing he was referring to as a second omnibus motion. I just was preparing that because I was under the understanding today was the final day. You already ruled on the eviction. You were going to rule on when and the damages. Okay, so since then, there were new things that happened, such as foreclosure being posted. I've lost a lot of orders and I'm out of business. So starting damages.
You're out of business?
Yes, and I do not have enough orders to pay my lease starting April. Most of the boarders are leaving at the end of March. They saw the posting on the door. Horse owners are like horses, they're flight animals, they're herd animals, and they're all leaving, and I'm going out of business. And so I fear, because of the posting of his foreclosure on the facility, that he is foreclosing and possibly going into bankruptcy. And so what I'm asking for damages is that it be to come out of the court's account. And that, so that my understanding is damages is up to you. And I have no recourse to get any of my money. I'm out of business. I'm not going to have the money for April's lease because of the eviction.
Let me just stop you there a moment, okay? Because you know about the foreclosure
Yes,
council and it's a bank foreclosure.
it wasn't a bank foreclosure, but it was the lender.
Well, okay, the lender. Have they leaned anything in regard to that?
I'm not aware of a lien. There was a foreclosure sale on the 4th, which the lender purchased the property out of foreclosure. So the redemption period is obviously still ongoing, but
Oh dear. Okay. And so when we had received, and I don't know if you were aware of it, counsel, I think it may have come in maybe in response to your motion to withdraw, communication from your client that it was going into foreclosure. But it actually has gone through that process, and then
yeah. And so I just want to make sure that we're clear. So there's the foreclosure sale on the property at issue on the 4th. My client's personal house is also subject to another upcoming foreclosure sale.
That's a different one.
Those are different.
Got it. Okay. And so you have to remind me, how long is that redemption? That's not a 6-month redemption, is it? Going to be
I believe it's 3, but
3. Yeah, that's what I was thinking. Go ahead. You were.
I filed this motion so that you would have all the information in front of you so that you could make a final decision on damages. Or whatever it's called. He asked me to be, he evicted me. He asked me to leave. I'm prepared to leave. I've found a place for my horses. Most of my boarders have already given me notice. And because of the foreclosure and the eviction, the fences that have always been falling down are falling down worse. I can't keep the horses safe, but I don't have the wherewithal or the resources to fix them. And I can't go on. And I'm prepared to, if you would be willing to prorate into the court's account 10 days in April, I would be prepared to leave in 30 days from now. And
What did you mean by that prorate into?
well, like, so I usually pay at the beginning of the month for the whole month. I won't have the money to do that because majority of workers
Gotcha.
are leaving.
I guess, okay.
Yeah.
What you're saying. All right. This is gonna be a disaster in the making, I think. When let me do this. While not holding him to it, counsel, is your client seeking to redeem the property or?
I believe in the best case scenario, yes.
Gotcha. Okay. You guys are gonna have to, so let's say he does, a new owner of the premises, you're probably gonna have to leave in any event. So when can you guys leave the property?
I would love to leave April 10th, but I can leave at the end of March, if you're not able to give me a prorated lease payment for the 10 days of April.
What do you have? I told him in escrow.
20,620.
Say again.
20,625.
I'm sorry, Your Honor, you said that's what's in the court's escrow?
Yeah, I was asking. It was 2625.
20,625.
And you folks have already paid the March payment. What?
Quick question, the March payment, are we saying that was paid into the court's escrow?
Yes, they said they paid that.
Last one being February 5th.
So you don't have a March.
June 28th March.
I didn't bring the receipt with me, but I did pay it March. I paid it. Did I pay it at the end of February because it was before we left on vacation? I think I paid it the last Friday of March because we left on vacation Sunday. So I want to make sure it was in before we left.
Did you pay?
I'm sorry, the last Friday of February. We paid it cash the last Friday of February.
Did you pay it here?
Or in Selene.
Well,
It really wouldn't matter. Do you know what court you went to pay it?
no.
I do see it because you paid it here. It's not on the ROA. So
And then it's got to be transferred over. So 5,500 additional.
so $26,125.
How long was your lease?
It was supposed to be 7 years.
You have how many horses are you moving?
I'm sorry, how many am I moving?
How many? Yeah.
Just my personal horses. Everybody else,
Okay, that doesn't answer my question. You're getting like that other guy.
I own.
3. So come the 10th as you're anticipating, you're moving 3 horses, or are you moving 3 horses and then some others that you're in care of? I guess I'm trying to.
There's 3 other horses that are absentee owners, and I haven't reached out to them yet because I was waiting to see when my leave date was. I'm going to reach out to them and see if they want me to take them because I'm just going to a friend of the family's and they're just pasture horses. But no, I'm not continuing this business. Does that make sense?
No, well, yeah, there's a lot more information I needed, but I'm just trying to figure out if I were to give you till the 10th, you're moving at least 3 horses, but up to 6
Yes.
total horses.
Me personally, yes.
Right. Okay. And as you're moving them, I know approximately what it's going to cost to move horses, but I don't know how far you're going. What's your cost in moving those horses?
Mm.
Just give me your three.
$100. I mean, if that. It's my trailer, my truck,
Okay.
my gas.
So you don't gotcha.
Correct.
All right. Okay, before I make a final determination of the damages on this, any other additional argument you want to make regarding the?
Yeah, a couple points,
Yes, sir.
just so that when I'm on the same page and we're all on the same page. So I have back in June of 2025 was the last rent payment. And it was a partial payment. That was the water heater. Subsequent to that, until this court directed Ms. Tope and defendants to submit money to the court's escrow, I believe there was the subject of a number of hearings prior to this that Ms. Tope had an escrow account personally where she was maintaining monies of some sort for June until, because I have, for example, as of March, a total outstanding rent due of $48,691.04. $26,125 of that is accounted for in the court's escrow account. The other $22,000 and some change might be in Ms. Tope's escrow account, which started this whole issue. And so
can I just stop you there? That you understand what counsel's indicating about the difference in the money?
One correction, I did pay 16 Houses LLC directly in July. I paid them the full amount in July.
Okay, but we still have a discrepancy amount. So I'm going to ask you folks a question, okay? Did you give that money of these missing, I'll call them missing, but the payments that did not get to the plaintiff, did you give those monies to Ms. Tope?
They were dispersed. That's the money that was dispersed for repairs.
Okay, but what I said, yeah, okay.
Yes.
Hold it. You did not, okay, listen closely to my question because it's really important. You did not disperse those funds for repairs, right? You gave that money to Ms. Tope, who was holding it in whatever to then disperse for repairs or pay for.
Yes.
Okay, because hold on, understand, there's a reason why I'm asking this, and there's a big difference. Okay, because what counsel's indicating, I believe is correct, but I just want to make sure on the record that we have it. The $5,500 that you would pay each month that you would have normally paid to the landlord in this case, there were some months you paid those funds to Ms. Tope to hold and or to use for repairs and other things.
I believe that was August, September, October, July. I paid.
Hang on a second. Hang on. Just slow down. I didn't ask what months. I want to make sure that factually because Ms. Tope's not here, factually that's correct. Because that's what I understand also, but I don't know that you've ever been asked that directly.
Yes.
Okay. So there's then this escrow, and you're saying that that was 3 months. If I'm hearing you correctly, that you would have given the monies to Miss Tote.
I would have to look at the accounting records, but I believe it was August, September, October. I believe it was 3 months.
August, September.
November, it paid support, right?
Our first payment was, I think that's right.
So just so that we're on the same page, I believe the November payment was paid to my client and it was a partial
It
payment.
was a partial payment in November. Right. So,
But I also paid
but you paid the difference of the 55 to the court. No, you paid the 55, but part of it was the check he received.
It was a double payment that month because of an error by Ms. Tope. So he received the check from Ms. Tope. We also made the payment. So that month had extra.
I believe in November, we paid the full 5,500 to the court. Is that correct? So was it 41?
You pull me
25 is what we.
You received it
41.25.
Yes.
He got 3,600.
on top of that.
So it was more than the 5,500.
It was $3,508.96.
I remember that being paid. That because that was a check Ms. Tope sent to him, right?
I don't know how we got it, but my records show that we got it.
Right, that you got it. And the question was whether or not you could pay or whether or not you could use it. And because there was then the full amount, I said, you guys keep that money. The difference I thought was being paid into the court.
And so I accounted for that in my previously stated number. So I'm just trying to bridge the gap between what the court has and what hopefully should be in Ms. Tope's escrow, personal escrow account.
Okay. And that number you gave me was 48,691.40.
Not 44, so 4 cents.
4 cents.
4 cents.
In November, though, it was overpayment. Because we paid
Well-
25 and 3,500.
Well, I don't know. We can really look at it as an over.
Okay.
I mean, because ultimately there's going to be a certain amount that should have been paid. The real question is where it went. I guess is that.
I think that's what you were going to ask for.
Yeah, that's what it was. Okay, and I know why that happened. What I did is I think I prorated. So I allowed him to keep the check. It really wasn't a double payment. So here's what I recall doing is the money that was sent to the plaintiff, I allowed him to keep that upon the court's original. And then when ordering escrow, I ordered it pursuant to the court rules so that it was ordered prorated for the period in time. And I went back, although you paid it on the 18th, it was back around the beginning. When was our first? You didn't run the whole thing, but whatever our first date in November was, I prorated it from a date in November, which is how we came up with that number. So there wasn't a full amount that was going to need to be paid in November. All right. You complied with the escrow order. If you didn't understand all that technicality and what I just said, but I understand why that number is different. And I didn't order the whole 55 for November. All right. But in terms, okay, so here's going to be the problem. And I don't know whose problem it's going to be. and this is gonna I don't think that the monies you paid were properly put into a trust account with Miss Toe. That causes huge problems, which I don't know what I'm going to do with it because and I'm not sure of the procedure, but typically, and I know it's changed certainly since I've had to do it, where an escrow account or an IOLTA account is mismanaged, there are ways to the state bar of making the person whole. Now, having said that, and that's there used to be, well, I'm sure there's got to be a way of doing that, but I just don't know how that is. Because you guys are never going to see, well, let's put it this way. You guys are never going to see that this time. Have you asked her for the money back?
No, we're not.
I don't think that money's there. I think that that's the money that was used for replacing the sheds and all of that. So,
That's not as.
okay, no, I'm never gonna get
But-
my money back.
Here's the problem, okay? And just follow this here. Okay, and I think, guys, he's got an Alabama shirt on. Tackle him. No, I'm kidding. Under the terms of the lease, which is the basis upon which I indicated the monies, you have to pay them, right? That money should have been paid over the plaintiff. Okay?
Money should have been paid every month.
Been paid over to the plaintiff.
Should have been paid
Yes.
over to the plaintiff. Okay? I ruled that.
Yes.
Okay. The problem is that it's hard. So I can't really necessarily give an offset. What really should happen in this case, right? Everything being equal and everything being what it is, and if Miss Tope were participating as one would think a member of the bar should, what should happen is the moment that I ruled that that money should have gone to plaintiff, regardless of whether she spent it on, if she did that improperly out of an IOLTA account, she should then pay that money to plaintiff. Right? You guys wouldn't have to pay more. Okay. That's not gonna happen. I don't think. So while let me put it this way. She may have told you those were legitimate expenses. They weren't legitimate expenses.
I hear you.
And so what I'm toiling with, just to be honest with you, is in looking at these numbers, do I hold you accountable for that? Or what do I do with it? Now, I'm toiling with that because also, which is also part of the hearing that I adjourned to the 17th. And why I would be reluctant to let counsel out right at this moment in any event, although it may be moot, is because the bond that I set on the contempt, that would be money that Ms. Tope may pay in, was specifically going to be directed toward attorney fees that were being exponentially imploded because of Ms. Tope's actions. So I'm going to ask you guys to just give me a few minutes. I'm going to step off because that my problem is everybody in this courtroom has been hurt by this person. And I'm trying to find an equitable way to deal with that. Counselor.
I have one suggestion.
Yeah, sure.
And theoretically, how it should work is if the defendants have paid money to their attorneys and I owe the account, equitably, that's still their money, which as you alluded to, would mean that that money is no longer there. They would have a claim against Ms. Tope, most likely through the bar agreements or whatever form they choose. My client does not have that remedy. And so, because we don't have a relationship with Ms. Tope. She's not my client's counsel. She didn't hold, I don't have an IELTS account with her, or neither does my client, for example. So in this scenario, the money that was in there, the defendants, I mean, their contractual obligation is still on them. So if they pay, then their remedy would be, they would actually have a remedy to get it from Ms. Tope, where my client really theoretically would not. I mean, there might be a creative way to do that, but I'm not aware of this. I've never had a situation like this before, but
you wouldn't me either. But no, I hear you. And that really had gone through my mind. But and that may be where I land in the next 15 minutes, right? But this is the second case in which Ms. Tope has been involved where people have been damaged. This is really the only one, however, that has damaged both sides, and then to a certain extent, the attorney on the other side, because your fees haven't been paid. And I want to just take a moment to think all that through. If I come up with something creative, I may come up with something creative, or I may not. I mean, I may indeed, and I appreciate what you're saying, counsel. That's where I may land. But I want to just think about that for a moment, because I, quite frankly, have never been through anything like this before either. And, you know, your client's out, your fees, plus he hasn't gotten the rental income. These folks have paid they're out at least what that difference is because they paid it over. So, and now because of all of that, and I'm not saying it's the entire cause, but because of all of that, he's in foreclosure. You're not in business. It's a beautiful scenario. And it shouldn't be how things should work. And over my 26 years, I'm not sure I've seen one person cause this much damage. Court's going to stand in brief recess.
All right. All right. 14A District Court for County of Washington State of Michigan is now back in session. Now with the day subject to the
Baby student. We are back on the record in the case of fixing housing 401k plan versus the wards. Council is present, wards are present. Folks, here's what I'm gonna do, and let me just explain the beginning of one of the things I wanted to check on during my break. There may not be a remedy through the bar. The only reason I say that is because at a previous hearing, Ms. Tope had indicated she was not acting as an attorney, and therefore there was no need to put it into an IOTA. True or not, I'm just saying what was said. Taking that into account, I'm going to do it this way. I am going to award judgment to the plaintiff, the monetary part in the amount of $48,691.40. I am going to order that the $26,125 is to be paid to the plaintiff. The resulting balance, I'm going to indicate, cannot be that no collection proceedings regarding that amount can begin against the wards until May 31st. I'm picking that date to give them time to figure out if they have other remedies regarding that balance, and give them time to sort that out. Should they seek to get counsel? Should they seek to go to the bar? Whatever they may wish to do. So I'm giving that time frame. I am going to order that an order of eviction will not issue, can issue April 30th. I'm going to give additional time for to vacate the premises. You can have until, I mean, if you get out the 10th, that's fine, but they can't do anything until the 30th. I'm going to give you the month of April to get out.
Okay,
Yes.
it is what it is, but I don't know that I'll have the money to pay the lease at the beginning of April.
Now, I am not going to order that the $5,500 for April.
Payments,
No payments for April. March is already in, right?
So no additional payments at the conclusion of this hearing, period.
Provided you vacate the premises by April 30th. If you're out of the premises May 1, you owe April.
Okay, so no additional lease payments, period. Unless I don't leave.
Right. If you're not out in April, then you need to pay the monthly. You have to pay April and then the subsequent May month.
Okay.
So you'll have to pay $11,000.
Okay. And the 26,125 is the number that you came up with that I paid into the court's escrow.
That is the amount we have in escrow.
Okay. And
That's
so the
paid over to the plaintiff.
what we're still trying to figure out now, will my $7,500 security deposit come out of that balance? So would I pay it?
I typically do not deal in a landlord tenant proceeding because there's a whole nother section of statutes that apply to security deposits. I don't deal with nor take into account that. Since I will say this amount, since the amount of these amounts are rent under the Security Deposit Act, he can take that $7,500 and apply it to whatever rents due. So theoretically, it would go against this in any event.
It should go against then.
Well,
money.
ma'am, what did I just say? I said basically the framework of the Security Deposit Act is that I am not ruling that.
Okay.
Because I don't deal with the security deposit because you have not vacated the premises. All right. The other thing, one last thing is that the hearing, Ms. Tobe's hearing, I'm going to move that from the 17th to the 18th at 9 a.m. at a special time. I do not need the parties here currently present because I don't know that you have an interest in it. I will indicate to counsel, as I had said at the last proceeding, the amount that I had set on bond on that was to cover attorney fees that were related to the delays on that. if you would, so that you do not have to appear at that hearing, if you can submit a billing to my office that we can just hold so that I at least have that figure in mind.
I have an affidavit right here.
Fantastic.
It's current as of today. So if we don't have to show up for the next one, this should be sufficient.
All right, fantastic.
And I'll just let the, we have redacted invoices, or like see unredacted invoices. I highlighted the days. You'll see.
Got it.
But if you want to see the unredacted ones, have to provide that for an in-camera.
All right. And I don't know that I'm going to need that because counsel, I think I trust you, and certainly I don't think your firm would allow you to give me something that wasn't right. So, all right. All right. Okay. Anything else?
What do I do next to, like, is this done? Do I have to, am I?
This case is done. I've
this case is
issued,
adjourned?
it's done because I've issued the date that you can stay in the premises.
Okay.
I've also now ruled on the issue of liability with the monetary amounts that I've indicated.
Right, but I'll hear from them about that at some point.
I would imagine you
Okay, so I don't need to
Okay.
do anything, okay?
you don't need to do anything so Ms. Ward, so that you understand what I'm doing. I'm not allowing them to take collection efforts as to that difference till May 30th, 31st of May. The reason I'm doing that is because, as I think I had indicated from the very beginning of this case, you may have claims as against Ms. Toe.
Okay,
That can come in various forms. Okay. And so I'm not suggesting one or the other. I'm just giving you an opportunity to explore your options as to how you remedy this. Because here's the cold hard reality. You're going to be out an additional whatever amount unless somebody makes that up. But counsel's right. It's not the plaintiff's obligation to do that. It's going to be whatever you decide to explore that.
okay.
Okay?
So is there gonna be something signed and sent to me, or
Counsel will prepare an order. Counsel for the plaintiff will prepare an order for the courts.
I'll get a copy, and so I'll know that it's done and I never have to see you again?
Well, thanks for saying it there. But I appreciate it. Yeah.
Okay.
Yeah, you guys don't have to come back.
Awesome.
All right?
One logistical question.
Yes.
Escrow amount. We need to take this up with and clerk and what I need to do on my end to get that transfer.
We can do it one of two ways.
You ordered it released to plaintiff, so this.
But it will be released to plaintiff's counsel.
For example,
Correct, it goes directly to counsel.
It goes directly to counsel. So my question is, since he's here, the only one that may not be able to be paid out is this new one, right?
So all the money is technically in Celine. So Celine has to release it and our money needs to go to Celine. So
Got it.
I can,
Okay, so
I can let them,
you don't need, unless you wanted it today.
I don't necessarily think we need it today, but better sooner rather than later. And my
All
always with both courthouses to get that accomplished as soon as possible.
What I'll have my staff do is try to expedite, because it's here, right? And it's got to go there.
yes, both places, but I can email the senior.
No, but the new payment is here.
Yes, sir.
So the new payment, we've got to get over to 4 to get into their drawer or whatever that is. And then it can be sent out. So what I'll have my staff do is expedite that process and then expedite the other end for the release of the check to your office.
Sure.
All right. So you don't have to do anything. We'll take care of it. If you don't see it, then call anybody but me, because I don't deal with that. But all right. All right. Thank you, folks.
Thank you.
Thank you.
All right, this is case 25-1845, joined with case 25-1847, and it looks like there's also a ticket. Number 25M300611 VOI. People of the state of Michigan versus McKenna Reardon. And for the record,
Hey, Judge, I think this is actually Meridian Township versus McKenna Reardon, I believe. What's that?
still the.
Oh, okay. Yes, Judge, I am here on behalf of McKenna Reardon, Tiffany DeRuin, P75073. She is standing to my left at council table.
What brings you to our court today?
So we have a plea agreement on the table, and my understanding is that my client will plead guilty to minor with a BAC and open container, and prosecutor Harkness agreed to dismiss the balance.
Okay.
And we do have, and I submitted to the court, the MAD victim impact panel, alcohol highway safety completion, and the substance abuse evaluation for the court's consideration.
Look like you're very afraid of something.
I'm just nervous, Your Honor.
What are you nervous about?
I've never been in this situation.
Well, hopefully you will never be in a situation like this again. Have you had enough time to speak with your lawyer?
Yes, I have. Your Honor.
Has she been able to answer all of your questions and address any concerns you have?
Yes, Your Honor.
Then you should be able to breathe a little bit easier. Okay? So do you understand what we're doing here today?
I do.
Explain to me briefly what you think we're doing.
We are going over my plea charges and discussing my case.
You're in college, aren't you?
I am.
You're at the university here.
Yes, I'm at Michigan State University.
What do you study?
I'm studying kinesiology.
Study of muscles and their movements.
Yes.
So that's a scientific endeavor.
Yes, it is.
So this should not be very hard for you to understand at all then, if you can understand science.
Yes, no, Your Honor.
So Mr. Bruin has placed before the court a request to allow for you to plead guilty to the added count of operating with a BAC while you're a minor, that you're under the age of 21. And if I accept that plea, along with having open intox, you could potentially go to jail for up to 90 days and have a fine of $100 for the open intox and $250 for the minor with any BAC. There's also cost recovery that is being requested in the amount of $217.14. And there's also going to be a fee that would be payable to the prosecutor for their time, which is about $125. Importantly, if you do have a license, your license is subject to being suspended. It might mean that your insurance costs could go up and things like that. So you understand that?
Yes, Your Honor.
Understanding that, you still want to go forward with the entry of your plea?
Yes, Your Honor.
Raise your right hand. Do you swear or affirm that the information that you're going to provide to the court will be the whole truth?
Yes.
Lower your hand. Want to make sure that you're doing this voluntarily. Has anyone threatened you or forced you to get you to do this?
No.
Has anyone made any promises to you to get you to do this?
No.
So you're pleading guilty because you are in fact guilty?
Yes, Your Honor.
And this is your own personal choice.
Yes, Your Honor.
You've had plenty of time to speak to Mr. Bruin about this beforehand.
Yes, Your Honor.
She's been able to answer all of the questions and address any of your concerns.
Yes, Your Honor.
Mr. Bruin?
Thank you, Your Honor. Would the court like me to elicit a factual basis at this point?
That would be appropriate.
Thank you. So, Ms. Reardon, on or about November 18th of 2025, were you operating a motor vehicle
Yes, I was.
on Grand River Avenue near East Brookfield Drive?
Yes.
Is that in Meridian Township, Ingham County, state of Michigan?
Yes.
Prior to operating that motor vehicle, had you had something to drink?
Yes.
What did you have to drink?
I had 3 glasses of wine.
Okay, and you came into contact with police officers that evening?
Yes, I did.
And is that because you did not have your headlights on?
Yes.
And was it dark at that point?
Yes.
To the point where you should have had your headlights on?
Yes.
So are you challenging the validity of the stop at this point?
No, no.
So based on that interaction with the police, did you then have your breath or your blood tested for alcohol?
Yes.
And what were the results of that test, if you know?
0.09.
Do you have any reason to question the validity of that test?
No.
And when officers approached the vehicle, was there a can or a bottle or a container of alcohol in your vehicle?
Yes,
And had the seal been broken?
yes,
So that was open, and you are how old?
20.
Your Honor, I do believe that should satisfy the factual basis.
Looks like the matter is properly within the jurisdiction of the court, having occurred in Meridian Township, Ingham County, State of Michigan, on or about November 8th, 2025. Further find that the defendant has knowingly, intelligently, and accurately provided the court with sufficient factual basis to find her guilty of being an operator with the BAC that is over what would be allowed for a person her age at 0.09, and that the requirements for finding responsibility for the open intox have also been satisfied. I believe at this juncture I will dismiss file 25-300611BOI. Mr. Brunder, you can agree that the court has complied with the court rules and taken a plea in this matter.
I do, Your Honor.
Okay. Then I will dismiss that ticket as we were just discussing. Okay, I have an assessment, looks like it was prepared by someone by the name of Samuel Gross.
Yes, Judge.
Is that what you were submitting to the court for this purpose?
Yes, I submitted the substance abuse evaluation, completion of MAD victim impact panel, and alcohol safety program.
Do you believe the report to be factually accurate?
I do.
Ms. Reardon, do you believe the report to be factually accurate?
I do.
You'd like to allocute?
Thank you, Your Honor. I know that there are several purposes of sentencing, that being punishment, deterrence, rehabilitation, and protection of society. I understand that Ms. Reardon is 20, and I also understand what her assessment suggests. I believe that she has re-engaged in outpatient counseling through MSU. This is a young lady that is going places. She is on the rowing team at MSU. Right now, she is off on injured reserve. She has absolutely no prior criminal history. She's never failed to appear at a court hearing or had any issues involving the court. I do know that she has some mental health diagnoses that she's addressing, which I think are the reason for the outpatient counseling through MSU. And her counselor can certainly address any concerns that are seen with the, with the substance abuse, if there are any. Sam does not necessarily recommend anything specifically for substance abuse. It's my understanding that he says he would recommend she maintain the medication review appointments with the physician. She is doing very well in school. She has family support. Her mother is currently in the gallery and has been actively involved in her in this situation, I guess. She and I have spoken about the case along with me speaking with my client herself. I think I've had some conversations with her father as well. I think the family is kind of sufficiently scared at this point, and they understand that this is not just something that can be swept under the rug. This is something that will affect her. She wants to be a physical therapist. She is in her junior year at MSU right now, and again, is doing very well. She lives in Pennsylvania. Again, Judge, I'll let her tell you what she learned through the MAD Victim Impact Panel and Alcohol Highway Safety course. But what I will say is she's on the varsity women's rowing team. She is very active. I think that what she has done thus far, being the MAD Victim Impact Panel and Alcohol Highway Safety Program, along with the involvement in the court case itself, have worked to sufficiently impact her for purposes of moving forward. And I think if the court, based on the charge that she pled guilty to, I think that any sentence, including fines and costs, would sufficiently deter and act as punishment for her and deter others from doing something similar. With regard to protection of society and rehabilitation, again, I think the things that she has already done work to effectuate that purpose. And I'm not sure that placing her on probation would give any additional services that are necessary. So it would be our respectful request to the court that she be sentenced to fine and costs. If the court feels probation is appropriate, we would be requesting a non-reporting probation. I believe that she finishes for the summer here in a couple months. And then I think she's going to be returning home to Pennsylvania, where she's going to be requesting, she's trying to secure an internship position for the summer before she comes back to finish her final year of school. So that's what we would be requesting today, Judge. Thank you.
Probably not going to do any of that. You have a history of drinking. You're underage. It says here that you first used alcohol when you were 50. It's
Yes.
crazy. And you're still not legal to drink, and you've been drinking, and now you've gotten criminal cases as a result of that. So I'm probably not going to do any of that stuff. There's a larger question here, and that is, why is it that you, as a young person, feel the need to use as much alcohol as you've been using? And it says, I'm just looking at what your assessment says. It's from 7 to 10 mixed drinks and a few shots of liquor 4 times a week.
Yes, Your Honor. That was this past semester. I think
But remember what I said, you started at the age of 15. The literature that I've read many years ago says that if you start drinking before the age of 15, you're much, I think it said it was 3 to 4 times more likely to have a problem. You probably read that yourself.
yes.
That is disquieting. So I'm interested to find out what your thoughts are.
I believe that it was my decision, and a lot. I would feel like my surroundings a lot of my life. So I never really looked at it as poor of a decision as it is.
It's a huge decision.
Yes,
All of the literature says that you can't drink before the age of 21.
yes.
I don't know how you got alcohol at that age, at 15, unless you just took it from your home. And that's an indictment of your parents if they allowed that to happen. Is that what you're doing, issuing an indictment against your mother? I mean, she's here.
No, I'm not.
So what are you saying to me then?
I'm saying that I am not totally sure.
Can I ask you just a very plain question? What created this desire for you to consume something that you had to know was improper for you to consume?
I think social settings, Your Honor, and not wanting to be the only one not doing it. Your Honor.
Okay. So how is it that teenagers are in a position where there's a social setting where is that sort of pressure being placed on them to consume alcohol?
I'm not sure, Your Honor.
So you do understand that you have to be at least the age of 21?
Yes, Your Honor.
Let me ask you a question because you may not have ever thought about this, but I just like to ask you this question. Why? Why is it necessary for you to consume alcohol?
I don't believe it is necessary. Again, like I said before, I think that, just in general, being in college and high school, it's, just something and I think, with the people I used to surround myself with, it was more common.
Why did you surround yourself with people that were doing illegal things?
I'm not sure, Your Honor. They were good people.
Well, I would beg to differ with you if they had you doing things that are against the law. I mean, you weren't knocking old ladies in the head, but certainly you were doing things that were illegal. And it dates back to when you were 15.
I think what I meant by that, Your Honor, would be like their kindness, not necessarily their actions, the type of person that they are.
That means that you're not a real good judge of character then, if that's what you were relying on.
I guess you're right, Your Honor.
Well, let me ask you, because the other thing that occurs to me too is that this has continued over the years and actually increased to the point of 7 to 10 drinks. It's a lot.
Yes, sir.
That's a lot for even an experienced drinker.
Yes, sir.
How often were you doing that?
Last semester, about 4 times a week.
No, I'm not a big, huge fan of putting labels on people, but you sound like an experienced drinker.
Yes, sir.
And you realize that's not the reason that your parents sent you off to college.
I understand now.
Then why were you doing this?
I'm not sure, Your Honor. And some situations in my mind, I used it as a way to cope. I know it's not right, but that's just what happened.
What happened to your health that you were not able to complete the rowing team?
I had to get surgery. I had an appendectomy, and then afterwards, my mental health. Sorry.
Take your time. And I need you to breathe. Breathing is very important, right? Because if you don't breathe, you could potentially pass out. So I need you to breathe. Take your time. Don't even start talking yet. I want you to just get your breath back, okay? Breathing is vitally important. That's good. Get centered. Let me just tell you, maybe you've already picked this up, but you make me very concerned. I mean, you're underage and you're drinking heavily. And I wonder how much of that is connected to you just being socially disconnected to what's happening at the college because of not only the drinking behavior, but you're sort of on this team, which is kind of an exclusive environment to be in because you have team practices and you got competitions and all that stuff. So there's nobody to balance off what it is that you're doing. Nobody to tell you that, hey, girl, this might not be a good idea for you to be doing all this. And if you're surrounded by people that are encouraging you, you need a whole new circle of friends. So now that you've been able to catch your breath a little bit, go ahead. I'm ready to listen to you.
Your Honor, my circle of friends are all on the rowing team. They are good influences. They're all 21 except for me. They do not
Let me just add a little bit for your consideration because it's the thing that occurs to me that I don't care how old they are. If they're drinking like you're drinking.
They are not, Your Honor.
Okay, good.
I was the only one. And it picked up when I stopped rowing. I felt like I lost myself.
So let's talk about that for just a second, okay? Why would you feel lost because you lose rowing for a little bit?
It's something I've done my entire life. I've always been an athlete. I've always been grounded in practices and schedules and expectations.
But is that really true if you've got this really strong ability to drink?
It is true, Your Honor. I've never once hindered my athletic performance with alcohol.
Not what I was saying. I'm saying, is it really true? Because you can live a double life, which it sounds like you were doing. That you're an athlete on one side, but you are an emerging alcoholic on the other side. I can't even believe that I could consume 7 drinks if I was trying to consume 7 drinks.
Yes, Your Honor, I know it was a lot. Again, when I was actively rowing, that was not the case at all. It's when I stopped that things started to pick up.
But you can understand why somebody listening to you would be concerned.
Yes, I understand.
Okay. Are you receiving mental health services?
I am. I have been for the past few months, right after this had happened.
Well, I saw where it mentioned outpatient, but I'm wondering if that actually helps you.
It does, Your Honor. It allows me with my classes and everything to have enough time to study and get my work done and still get the mental help I need.
Let me tell you, because you probably don't know anybody that thinks the way that I think. So let me just tell you, all of the stuff that you do doesn't matter. The thing that matters to me is you and being a whole person who has the ability to grow and to mature in our society. If you lose rowing, or if you lose school, or if you lose something else, that may just be the cost of what is necessary for you to be able to be a whole person as you make your way through your life. So if you have to take a step back, if you need to abandon rowing, or if you need to drop out of school for a semester or two so that you can get things together, that might be the most important thing that you do. It's not the things, the activities and all of the hang-arounds and all that stuff that you're engaged in. That's not important. What's important is you and your mental health. And I don't know if anybody's ever told you that before. But I'll tell you.
Listen, Your Honor.
Yeah. So ordinarily, I would not think that a long period of probation would be necessary. And I think what I'm going to do is try and err on the side of caution even with that. So I'm looking at a period of probation of 6 months because I think, I'm not sure, but I think that you have the ability to do what it is that you want to do. But you got to be more careful and conscientious about what it is that you're doing and why it is that you're doing it, because it looks like to me that you've fallen into behaviors without really without really understanding what those behaviors actually mean to your overall mental health.
I understand, Your Honor. In the past few months, I have not touched alcohol. I've been focusing on myself and my therapy, and this is the first time that I've really broken down like this. I think that it's just a mix of stress and being in this courtroom.
I cry all the time too.
Yeah. So I have been working on myself, and I have realized that, you know, I am a lot more productive. I'm a lot better at school, at everything without the drinking side. I've been engaging in more activities at school. I just joined a volleyball team. I ran a half marathon on Sunday.
But you've engaged in a lot of intensive activity, and I wonder how much of that is a shield from what's really bothering you.
Well, Your Honor, I've worked through in therapy, coping methods.
Who is it that you're seeing for therapy?
Sorry.
Who is it that you're seeing for therapy?
Her name is Doris Patterson.
How long have you been seeing her?
I believe a month and a half to 2 months, if I'm remembering correctly.
Actually, a much more sustained relationship with her for now, the beneficial effect. But I'm glad to see that you're seeing someone.
Yes, and I understand that, Your Honor. I've been through therapy before, and I think this time, especially with the severity of what I've done and realizing that, you know, things did get out of control, and I needed to figure out how to deal with myself and my actions, and I wasn't speaking to anybody about it. That when I did start speaking to her and we started coming up with, you know, coping methods that weren't, you know, alcohol related, it allowed me to see things in a new light and allowed me to start acting on those things. And from my personal experience, Your Honor, the past 2 months I've been in therapy, I have been able to deal with a lot of the things that I've had so long built up that have just happened recently, that I've been able to cope with them and figure out how to control my emotions to then better control my actions.
So you have a psychological evaluation that's been done?
Yes, I believe so, by Sam or just by my therapist.
His was substance abuse.
Oh,
What I'm interested in seeing is your psychological evaluation
Okay.
to see what it is that they concluded and to see how it makes me feel once I read it.
Okay.
Because I want to make sure that I do what is required for you to have the kind of life you're supposed to have.
I understand.
So I'm going to place you on a period of probation of 6 months until I can get this sort of all sorted out. Okay? You want to order that you pay some fines and costs. Do you have the ability to pay fines and costs?
I do.
So the fine is $250. There's $125 state assessment, $675 in court costs, which I find to be reasonable based upon what it costs the court to handle cases like yours. There's $217.14 cost recovery for law enforcement. There's also $125 for the cost of the prosecution. And hold on for just a second. It's actually pretty expensive. Plus, there's $210 in oversight fees. Oversight fees is what it costs to be on probation. So I'm looking at 6 months and it's $35 a month. So that's $210. There's also a fine of $100 for the other case 25-1847. So the total is $1,702.14. Are you in a position to be able to pay that?
Yes, Your Honor.
Do you have the ability to pay that today?
Yes, Your Honor.
Okay. I'm going to say within 30 days, just in case you need a little bit of wiggle space, okay?
Okay.
But it's really not about the fines and costs. I would waive the fines and costs if you were in a position to pay that. More being focused on you and what needs to happen with you. So paid in full by April 10th. And if you need some additional time, let me know. Okay?
Okay, Your Honor. Thank you.
Okay. You're to meet with probation on a monthly basis or as directed. You're not to possess, carry, use, or purchase a firearm, ammunition, or other dangerous weapon. You're not to violate any criminal law of any unit of government. Not leave the state without the prior consent of the court. You're to make a truthful and accurate report to the probation officer at each contact. You're to notify probation within 24 hours of any change of address or employment and within 24 hours of any contact with the police. You're to provide proof of healthcare coverage or meet with the healthcare navigator as directed by probation. You're not to use, possess, consume, or be in the presence of alcoholic beverages or controlled substances, nor be present in any place where alcohol is sold for consumption on the premises. So no bars, no bowling alleys, no restaurants that serve alcohol or any other substances. You know, there are lots of drugs on college campuses, so marijuana, cocaine, whatever. Anything that can change your state of alertness is forbidden. You're not to use any products containing alcohol, poppy seeds, or any other illicit substance. You're not to abuse prescription and non-prescription drugs and provide verification of all prescriptions to your probation officer within 48 hours of obtaining the prescription. You're to attend counseling as recommended in the substance abuse assessment. You're to drop for probation, law enforcement, testing agents, case manager, physician, or counselor. 24 hours of community service by the end of probation. 11 o'clock p.m. curfew. Are you still working?
No, you're not at this time, Your Honor.
Okay. Then I'm not going to require that you maintain employment. I'm not going to even require that you look for a job at this point. It sounds like you've got great parental support. You keep our medical appointments, follow medical advice, take all medications as prescribed. You sign a release. Your license is subject to suspension. That'll be handled by the Secretary of State's office and depend upon your master driving record. You're to submit to fingerprinting by law enforcement as directed by probation, and you're to submit to a search of your person, your home, or your car upon the request of either probation or law enforcement officers who have cause to ensure you're in compliance with the terms and conditions of probation. Now, despite the fact that I've ordered all of these things, you may be able to appeal. If you decide to appeal, you need to do so within 21 days. And if you require the services of an attorney to help you with the appeal, and you can afford Mr. Bruin, and you should let me know within 14 days. Do you have any questions or concerns about what I've ordered? Mr. Bruin?
A couple of things, Judge. I think at the beginning, the judge said, or the court said that it was November 8th. I just want to clarify for purposes of the record, it was November 18th,
November 8th for what?
date of the incident.
Oh,
Okay. Number 2, Ms. Reardon lives in Virginia, Pennsylvania, sorry,
It's okay.
Southern states. And I believe she will be leaving or she hopes to go back home over the summer.
you know what? She just corrected herself. You don't get to leave once I say you can. You would have to stay here. I'm assuming that your parents are here.
No.
Where are your parents at?
Well, my mom's here today, but we all live in Pennsylvania.
Who are you with here?
My
Ouch.
roommates.
Okay.
So I would be requesting for her to be able to return back to Pennsylvania because she's seeking an internship and position there.
Not important in the grand scheme of things. Right now, we're focused on you, not anything else. That makes sense, really, right?
Yes.
That is all, Judge.
All right. We'll talk when the time arrives, but I'd like to see that evaluation that they did of you.
Okay.
Did you get one of those to Mr. Braun?
I'm sorry.
And if she gave you one of the.
No.
But you know.
I don't have it.
So I'm sure that Mr. Bruins would probably like to read that as well. I'm assuming you still have a copy of it.
I just have been going to therapy, so I've never.
I don't know if she got a mental health evaluation. I don't know that she got a psychological eval done, Judge.
Oh, that's what she just told me she did.
Well, I think you got a young person who doesn't always understand the terms that we use, terms of art. So I think she went to counseling, and I think her counselor decided that she could benefit from counseling. I don't know that there was a full psych eval done or mental health eval done.
I'd like for you to check and let me know, okay?
Okay.
You also should provide that to your attorney. I'm sure she'd be very highly interested to know as well. Maybe we need to set this for another hearing for me to have that received so that we can review that in tandem,
And Judge, can I ask what the purpose of that hearing would be?
so that I would know what it is that she has to do.
Is the court calling it a supplemental sentencing?
It's not really a supplemental sentencing. Well, it might be, depending on what they say. I just want to have the ability, the advantage of having some person who is a professional who has evaluated her to help to guide what it is that we're doing. I don't want to do something contrary to what the professional advice is that she's receiving.
And I think we have that, Judge. We have that in Sam Gross's evaluation.
Well, it doesn't touch on any of what we were just talking about, though.
As far as mental health goes, I can advise her to ask her practitioner as far as if they have anything, but if not, I certainly understand the court's position. If the court wants to set it for another hearing, we can. That'll give me some time to do some
I
research.
think that's probably well, how much time do you think you need?
A few weeks.
Okay. So 3 weeks from today would be about
March 31st is exactly 3 days or 3 weeks from today.
March 31st. What do we have going on then?
We could schedule something at 2:30 on March 31st.
I'm not available. I have a circuit court matter.
You don't have a partner that works with you?
I do not. It is just me. It's always been just me.
Superwoman.
I would disagree with you there, Judge.
April 2nd. 2:30.
I will be in Nashville Thursday, Friday.
Monday, April 6th at 10.
I get in from Nashville at 8:30 in Detroit. I'm not sure I can make it back here at 10.
So we can do it later in the afternoon? On Monday? How does that look?
3:30 would be the latest we could.
That's fine. I have that's fine. I have a board meeting at 4, but obviously this takes precedence.
Well, I could set it at earlier that afternoon, 3 o'clock.
Yeah, I don't think it'll take me that long. I don't know. I don't want to be late. Let's just put it that way.
I don't want you to be late. That would be bad.
I do know that, Judge. I've been in front of you enough to know that. And what time did you say, Miss Elaine?
3.
Yes, ma'am. Thank you.
So what's the date? April 6th?
That would be April 6th, Your Honor, at 3 o'clock.
Ms. Reardon, ma'am, Do you have any questions or concerns of me?
Yes, sir.
Sure.
Yes.
So as soon as you walk into the hallway, you'll probably say, I should have asked the judge about this.
No, Your Honor, I don't have any questions.
Just she has an open line of communication with me and I feel like I have on the report, so I can certainly arrange that if something comes up.
I would appreciate that. Have you ever been in like counseling services?
Yes.
When's the last time?
Other than recently, last spring, I started right after I got medically disqualified, and then before that, it had to have been constant throughout the summer, and then during the school year, I would take a break. And then before that, I've been in counseling since I was.
Do you feel like the counseling services help you?
I do.
And maybe that's how we will resolve things, is to make sure that you have some sort of certified counselor that you're talking to that is actually generating some sort of assessment, maybe every month or every 2 months or something like that.
Mhm.
Okay. But think about what I've said, and I want you to know something because it might not be apparent. The reason all of this is happening is because we care about what happens to you. I don't really care about school. I don't really care about the team and all that other stuff. All of that's going to be taken care of when you're taken care of. So we got to make sure that you're being taken care of first and foremost. Understood? Yeah. So we'll see you back on April 6th, okay?
Okay, thank you.
All right.
Good morning, sir. Are you Jaden James Corbiel?
Yes, sir.
Mr. Corbiel, you're charged with no insurance under the insurance code, driving suspended, and no valid license plate. The most serious charge is the no insurance. This allegedly occurred on February 21st. Some of it is under state statute and some of it is under ordinance. They say that it happened at 6:30 at night in White Pigeon. Some is under White Pigeon ordinance and some is under state statute. I would like to put you in jail right now with a bond of about $10 million. You have $2,278 worth of unpaid fines and costs. This is the fourth time in a year you've been driving without any insurance and you never pay the fine. 2023, no proof of insurance. 2024, no proof of insurance. 2024, no proof of insurance. 2025, no proof of insurance. We also have careless driving, possession of a firearm in a motor vehicle, speeding, failing to yield, defective equipment, and no vehicle endorsement. This is just 2024 and 2025.
Yes, Your Honor.
Your license is suspended. It's the fifth time you've been driving around without any insurance, and you just don't care. So I could set the bond at like $1 million. Leave you in jail till about next Halloween. You're also speeding. You just don't care. $2,278 worth of unpaid fines in the last 2 years. And then you're buzzing along exceeding the speed limit with no plate no insurance, and a suspended driver's license. What do you do, sir?
I work at Forest River. Can I explain my?
I don't want you to say anything at this point.
Okay.
Mr. Stickley would probably recommend you don't say anything. Let's say this, there's most likely jail in your future. You can't just keep doing this without some consequence. Ticket, don't pay it, ticket, don't pay it, ticket, don't pay it. This no insurance is punishable by up to a year in jail and a fine of not less than $200.
Yes, right.
Not more than $500. Driving suspended is punishable by up to 93 days in jail and a fine of up to $500.
Yes, right.
None of these are really all that hard to prove. You either had insurance or you didn't. You either had a license or you didn't.
Yes, right.
But in light of the fact that there's jail in your future, I think I should appoint an attorney for you.
Okay.
Now, I saw you had someone bring you in here and then you sat down here with your hat on, again, showing a lack of insight. Plea of not guilty, appoint an attorney, set attorney pretrial for 3/27/26 at 8:30. You live on Youngs Prairie Road and you work at Forest River, so you got to get back and forth to work. Do you have a way to get back and forth?
Yeah, I've been having my buddy, he travels back and forth since the day I've been pulled over, because when I got pulled over, I wasn't aware of my license being suspended.
You weren't aware your license was suspended?
No, I was aware.
Well, talk about not having a clue on the clue bus.
I was aware it was being reassessed. I had gotten that paper in the mail, but on that paper, it said my license was still valid. And then I was supposed to be sent another.
All right, well, you can explore that further with your lawyer.
Yes, Your Honor.
It says you're suspended as of the date they ran this, which was February 24th. You not to mention what I've got here. Holy smokes, you also got stuff in Cass County and Indiana.
I have something in Indiana, because that I'm not
You
aware
were going 80 and a 55 in Indiana in 2024.
Oh, okay, never mind. I'm aware of that one.
They used to suspend your license for not paying tickets, which I wholly agree with. It's called fail to comply with judgment, FCJ suspension. We have someone today that has an FCJ suspension from Coldwater. I can't tell why you're suspended. Probably because you have 1 million unpaid traffic tickets. Yes?
I was going to say, since the traffic stop, I was able to receive that paper that they suspended my license. It was due to having 14 points on my license.
Due to what?
Having 13 points on my license. And they said it was suspended up until April 6th, but I'm imagining it's probably going to get moved.
Well, if you don't, it could get extended. None of these have shown up on your driving record yet.
Okay.
But they will show us, the plate one won't. Driving suspended would. Anyway, what you're pointing out is all the more reason why perhaps you could use some legal help. You have a good job, but you haven't paid 1 cent toward any of your fines. I would suggest maybe you start doing that too.
That was my plan today. I am only a hand receiver, so I only make about 500 a week. And I'm on a payment plan for the tickets as of right now.
We've got a lot of those payment plan where no one makes a payment. What is a hand receiver? You receive hands?
No, so I put boxes away, stack shelves,
All right,
if
well,
there's a
everything
mess that gets made, then
leads to something else. All right, you go out to the counter. We're gonna get a lawyer for you. And see where this goes. But you've had a rough 2 years. Mr. Franks, would you come, why don't you just have a seat right here? Mr. Franks, you got a ticket for driving with a suspended driver's license. That's a misdemeanor in Michigan. It's punishable by up to 93 days in jail and a fine of up to $500.
Your Honor, I don't think the record's on.
Oh, yes, thank you, Tim. This is a misdemeanor. It's punishable by up to 93 days in jail and a fine of up to $500. The state of Michigan has suspended your driver's license. You had a medical examination last November. And for medical reasons, the state of Michigan has taken your driver's license away. Do you understand?
Medical reason they took.
The state,
I don't understand.
well, I don't know if you understand or not, but you can't drive anymore.
Yeah.
Or you
I
could
had
end
a
up,
good record too.
yes, it
Oh,
does.
the whole year, oh, you know.
It doesn't show that you have anything other than a traffic accident back in 2021.
Yeah, that's all I've had over all these years.
So I don't know the reasons, but
I'm 90.
you got referred for a medical evaluation and the state of Michigan took your license.
Huh? I didn't know that.
Well, I'm telling you now, you don't have a driver's license. You can't drive anymore, or you'll end up going to jail.
Oh, yeah. Hey,
So
I haven't changed none, you know.
I'm just a messenger.
Yeah.
The state of Michigan did a medical evaluation and they took your driver's license last November. Now, where were you going at 1 o'clock in the morning in Three Rivers?
I don't know what I was doing now. That was been a long time ago.
Yes, that's part of the reason why they took your driver's license away,
Yeah.
because you can't even remember what you were doing or where you were going.
Yeah.
Do you still own a car?
Yeah.
Well, you're gonna need to sell it or give it to somebody else.
Yeah.
Yes?
It's in my name, sir.
All right, your car's
That's
in
my
your,
daughter.
in your daughter's name. The Three Rivers City Attorney, Mr.
But I
George,
have a good record over all the years.
I don't disagree with that.
This is the
but-
first time I got in trouble with the law.
Well, that's why the city attorney is willing to dismiss the charge.
Oh, great. I mean,
So the charge is dismissed, but you can't drive anymore. I don't know where you were going at 1 o'clock in the morning in Three Rivers, and neither do you.
yeah.
That's not good. I don't know if you just woke up and got agitated and went up, took off.
Well, I've had, over the years, I've had no records at all, Harry.
All right, this was
And
on
this is one record
131.
Now I can't get to drive anymore.
You can't drive anymore.
Oh, God.
You were driving down one of the most dangerous pieces of highway in the state of Michigan
Oh,
at 1 o'clock in the morning. There have been 10 fatal accidents at that intersection.
yeah, but I have never been in an accident.
Well, you were in an accident in 2021.
Yeah, one time over all these years.
Well, all I'm telling
It
you
wasn't
is,
my fault.
okay, you can't drive anymore.
Okay.
Your daughter and her boyfriend are gonna look out for that. And the city attorney's agreed to dismiss the case. I would say you're doing pretty well for 88 years old, but at some point it becomes unsafe for you to drive. I witnessed this with my own family. My mother and father-in-law both had
Yeah,
their,
my mind's still sharp.
All right, well, mine, maybe a little bit.
Yeah.
Anyway, so if your mind is sharp, hear me, you can't drive anymore. The state took
Okay.
your license away, but the city attorney has dismissed the charge. You don't want to go to jail for this.
No.
All right, you're good to go.
Now I can't never drive again?
Not unless the state reinstates you.
Dad, I'm living with you. I will drive you.
Okay. Yeah, my daughter lives with me right.
All right, well, you're fortunate. You're free to go.
All right.
Thank you, sir. Yeah, thank you.
We had a gentleman a number of years ago, Judge Welty was still here. Thank you all, you're good to go.
Thank you.
Okay.
He was
This one.
very
Very
stubborn.
good, sir. Thank you.
Yes, thank you. He, I won't say his name, he was on the board of directors at Glen Oaks, a very prominent man. He actually had a law degree, but he never practiced law. He had a law degree from University of Notre Dame, and he was almost 100. He was in his 90s, and he kept driving. And he was like Mr. Magoo. He couldn't see, and he would be like driving down the sidewalk. And Gene Ali was the chief of police in Sturgis and just beside himself. The guy kept driving, and Judge Welty, and he also couldn't hear. So they're like shouting at him at the courtroom, and he would sneak the keys out of his wife's purse and he would take off, and well, it's fun. He wouldn't stop. I think he obviously must have known he was suspended, but I think they're gonna look out for him. Mr. George, I appreciate your compassion there. You're right, giving the guy a driving suspended ticket at this point. But if he does it again, we'll certainly deal with it. Anyway, that man eventually passed away, but he was adamant. I've been driving since, 2000 to 1926. And unfortunately, no one got hurt, but he was dangerous. And I remember being in that courtroom over there. I was still prosecutor. I'm just having my head in my hands. Anyway, God rest their soul. Gene Ali was an excellent chief of police in Sturgis. This gentleman was one of the founding board members at Glen Oaks, but he should have been driving. All right, we are back, and good morning, everyone. We're going to get started. We have just one sentence here. Tuesday morning is not a usual time for a sentence, but we made arrangements to do this one, and I think it will be fairly non-controversial. This is in the matter of Melinda K. Fowler. The file number is 251812 FD. You're Melinda Fowler?
Yes, sir.
Here with their lawyer, Mr. Ross Truckee. And I don't remember exactly why. I think it had to do with Ross's availability, but we set the matter for this morning at 11, and it seems to be a good time to do it. Also present is Mr. Matt Huff from the probation department, who's got a lot of background history on here, and Abigail Stoll from the prosecutor's office. Quite a bit of back behind the scenes work has been done on this case, and Matt and Autumn have been working in conjunction with the Kalamazoo County Probation Department, and we have our sobriety court, and they have one or more, and on several occasions they've referred people into our program, and on one or two we've referred them into their program. So through the substantial effort of Mr. Huff and Autumn Kiefer, Kalamazoo has agreed to accept you into their sobriety court program. which I think is a win-win. So, Ross, what would you like us to know?
I think just going back in time here to August 29th, there was an order entered by Judge Kane's court relating to Melinda's son, and relating to a drinking problem that created unsafe conditions. And then on September the 4th at the DHHS parking lot, where I believe parenting time was scheduled, we have this arrest. And it doesn't take too much to assume that rock bottom was either that day or real near there. Your son gets removed and placed in foster care because of your drinking, and then you're arrested outside of a parenting time. It's sad. It's sad for Melinda. It's especially sad for her son. Since then, through a couple of fits and starts and stumbles and adjournments, we eventually got here. Melinda completed an outpatient or an inpatient program at Our Hope in Grand Rapids. She was there. She worked with that team. They tried to help support her through this. She did a bit of jail in December. Your Honor placed her in jail partly because of the stumbles we'd had and the failure to appears and the different things of that nature. But that was a wake-up call. She's been grabbed by the shoulders and shaken violently by the world. And I hope that her eyes are coming into focus here, and that the sobriety court programming in Kalamazoo can get a foundation under her that lets her be the mother she wants to be. So I ask the court to just sentence to the sobriety court programming and transfer to Kalamazoo County.
Melinda, before I hear from you or Abigail, I would like to hear Matt's input. He and I have discussed this case, I don't know, but a dozen times over the last few months, tracking progress. And as Ross said, there was a jail component at the end of last year for the other offenses. But you've been working on your sobriety now since about November. Matt, what else would you like us to know?
Well, I think Ross did a pretty good job of explaining out what's been going on with Miss Fowler. I've worked with her in the past on the probation back in 2020. I got the distinct sense that she's trying to turn her life around right now. Some individuals often can use treatment as a guise to avoid any sort of sanction that might be there. And I don't think Miss Fowler's doing that. I think that she's a resident of Kalamazoo County. She wants to get better. She wants to get her custody of her child back. And I think that the 8th District Court Sobriety Court is going to be the best hope for her to do that. The sustained long-term intensive probation to make sure that she's instilling the right habits in her life. As Mr. Truckee did point out as well, she did do a substantial amount of jail up front. When they were
Well, I think she was using treatment to duck jail. So there was jail, but I don't think she is at this point. You said something interesting earlier this morning, that she's at this point, the essence of it was she's not just talking the talk, but she's actually walking the walk and doing more than just going to a few meetings or that sort of thing.
That's my impression.
Abigail, do you have any objection to her being placed into the Kalamazoo sobriety court treatment program?
I don't, Your Honor.
We've had a good working relationship with them. Both our cases transferred there and their cases transferred down. I think everybody that's been transferred from Kalamazoo County has successfully completed our program. We may have given one back. Anyway, Ms. Fowler, you look good today. How long's it been since you had your last drink?
145 days.
Good for you.
Thank
One
you.
day at a time. Where are you right now in the stage of your recovery?
I'm staying at a recovery house called Abigail's Palace in Kalamazoo.
What's it called?
Abigail's Palace.
Okay.
It's a support group. The women there support each other. I go to groups through the house. And then I do groups through ISK, which is treatment and groups, it's individual therapy, whatever I need. It's also dual diagnosis. So for people with addictions and mental health issues, is to help cover all of those things. And I'm just getting into that program. I go to daily AA or NA meetings. And then just various other things that are required or have been asked of me. I wholeheartedly accept all of them. I'm happy to do it.
Well, what happens next? Because at some point you got to walk or ride your bike without training wheels. And Ross says you really want to get some stability and get your own place.
So from here, I've already set up with HRI, which is the Housing Resources up in Kalamazoo. And then I can't think of the other program that I'm involved with through ISK. That's going to help me with housing, and they'll also help me with employment. There's a seminar I'm going to be going to March 31st at Urban Alliance. That'll help me with employment.
What kind of work have you done in the past?
I've done cashiering, factory work, you name it, food, all of that. So I'm hoping to hear back on a job that I talked to them yesterday about. So hopefully that opens up because they have flexibility with the scheduling as well.
Where are you from originally?
I'm from here. I'm from Mendon, Three Rivers area.
Okay, because you've got a lot of resources here in the county. Domestic assault reached out and helped, and you had some other stuff. For some reason, and you're in Kalamazoo primarily because that's where your treatment program is?
Well, the treatment, there's lots of opportunities up there, but also my son goes to Portage Central Schools. And so I want him to stay in the same school district. That's very important for his stability.
Now, you're not going to have a driver's license.
Correct.
But you'll have the opportunity to get a license through this program with an interlock. That's a blessing too. All right. This is the operating while intoxicated. This took a while for all this to unfold. And I don't want to downplay Mr. Truckey's efforts here either. He's been trying to get you into this program since he got involved in the case. And so things kind of evolved. You did your jail time. But what you also did is you kept doing what you were supposed to do. You didn't stumble, you didn't drop out of the program, you didn't relapse. You stayed on the recovery path, which led us to where we are today.
Can I say something as well, Your Honor?
Yes.
I just want to thank everybody that's helped me get to this point, get all these programs set up. And I do appreciate that.
Well, we contemplated putting you in our program. I'm the sobriety court judge, and I'm always looking for people to pull into the boat. But the logistics for you weren't going to work because you're in Kalamazoo. So this is an elegant solution to this problem. How much jail credit do we have
48
here?
days.
48 days.
And her bond was reduced to a PR bond December 23rd. So I don't believe we have any bond.
All right. I'm going to order 90 days, credit 48, leaving 42 deferred. And a 24-month probation. Some stuff I have to order. I'm going to waive the fine. There's a crime victims' rights fee of $75 and a state minimum fee. Was there any police reimbursement? Abigail, do you see one in your file anywhere?
Just a second, Your Honor, I'm sorry. I do not see one now.
All right, I'm not going to put one in. There will be fees in Kalamazoo, so I'm going to waive our oversight fee. Not that Mr. Truckey didn't deserve it, but I'm going to waive the attorney fee. No drugs and no alcohol. Participate in 8th District Court, Sobriety Court. I will see those folks at the treatment court conference in May. We went out to dinner with them one night a few years ago and had a nice time talking with them about how they do things. And sometimes I think that's the real value of conferences and meeting your colleagues. I hope this is going to work. You've got a lot to motivate you. 148 days of sobriety is 145 days is nothing to sneeze at, but it's a battle every day. Right now, you're in a sheltered environment and everybody, it's what happens next, but there's got to be a next. You can't stay in this program for the rest of your life, and you know that. So we're looking for next. When I run into my sobriety court people out on the street and see them, and talked to a guy the other day, he's been sober for 8 years, still has his interlock. I don't want you to have your interlock for 8 years. But he just kept it rather than get a full license. All right, your total fine here is $125. I can't make it any lower than that. As I indicated, there will be fees in Kalamazoo. I changed your bond to a PR bond. I'm going to make that due before probation ends. Matt will stay on top of this, connecting with them. He will also be going to the conference. All right, this is one of the easier things I've had to do lately. You really do look good. I've seen you at your worst.
Oh, yeah.
Nobody looks great in a green jumpsuit after they slept on a slab in a rough night, but you,
I recognize that I needed those days in jail, you know, gave me some clarity. Definitely did.
all right, good for you. Matt, you can take that. Actually, I thought Abigail's Palace was in Sherwood, but that might be a different palace. That might be a different, I think that's a different place. I think it is a palace, but it's different.
Thank you.
Abigail, do you have any insight on any of the prelims for this afternoon? Anybody share anything with you? We have the basketball player, Mr. Moss, and then Brandy Lemmerhart. Did you hear anything about either of those?
I'm not sure.
All right. Well, they're still on the docket. We got time set aside for them. I have my phone in my pocket. I bring it into court. Sometimes because I use it to scan QR codes, this is a fraudulent call, but I just had it in my pocket, so. I can use it to scan alleged Mexican driver's licenses and other things where they have a QR code on them. And you can tell whether they're real or not. This is the time and date set for preliminary examinations today. We had an earlier case, Mr. Justin Moss and his counsel have filed a waiver of preliminary examination, so that case will not be going. We also have a preliminary examination and a pretrial in the matter of People versus Brandy Nicole Lemmerhart. That's you?
Yeah.
And you're here with your lawyer, Sarissa Montag. Ms. Lemmerhart, there are two things set for today. One is a preliminary examination on a charge of possession of cocaine less than 25 grams. That allegedly occurred in the city of Constantine, I think. Pull that up. Yes. On or about November 13th. You're charged as a second offender, making that punishable potentially by up to 6 years imprisonment. Your lawyer, Ms. Montauk, is here. Also, Abby Stoll is here from the prosecutor's office. We're working on a resolution of both of these cases, but haven't quite gotten there. So if I understand correctly, you're going to waive the preliminary examination on the cocaine charge. We'll set the other charge, the retail fraud charge, for a final pretrial before jury. Is that your understanding, Ms. Montauk?
Yes, it is, Your Honor.
Ms. Lemmerhart, let me read you the waiver of preliminary examination, if I can find it. I, Brandy Nicole Lemmerhart, understand I have a right to employ an attorney. I may request a court-appointed attorney if I'm financially unable to employ one. I voluntarily waive my right to a preliminary examination and understand that I will be bound over to the circuit court on the charges in the complaint and warrant. Is that what you wish to do?
Yes.
That leaves open the opportunity for further negotiation. Ms. Montauk, do you have a waiver?
I don't, Your Honor.
Laura, could you print a waiver form for me in the Brandy Lemmerhart case?
Thank you, Judge.
The bond conditions in this matter are that you not leave the state of Michigan. I don't believe you're to use any drugs or any other controlled substance, take a test upon request of any court officer, and not commit any criminal violation. Do you understand?
Yes.
The retail fraud charge that you're charged with in 26344 SM occurred while you were on bond on this felony charge. Now that's an allegation at this point. It hasn't been proven, but I don't want to see any other charges come in here while you're on this felony bond. You were on felony bond when the second case allegedly occurred on February 23rd. The bond is setting an amount of $7,500 cash or surety. It's higher than I would have expected, but you posted bond and your bond is continued. I'd ask you to have your client execute that, and then we'll. At any rate, you've posted your bond, and as far as I can tell, your compliance. If I were to give you a drug test today, would it show anything?
Just from me, still probably from the other day. That would be it.
All right, well, you can't use anything, and we discussed that.
Right.
Now, the other charge, the retail fraud charge from Walmart, is a misdemeanor, punishable by up to a year in jail and a fine of up to $1,000. Those go on a different course of action. We're going to set that for a pretrial conference at a time that works for your client, for your lawyer. So let's take a look and see what we got here. Are you available on Thursday, March 26th at 2? We could also use April 2nd.
So March 26th, I have a hearing at 1:30 in Kalamazoo.
How about Thursday, April 2nd?
Well, that's funny because I'm scheduled to be.
Yeah, you're here with Mr. Zablocki.
But it is Passover and I'm going to be in New Jersey. So I'm working on getting that changed.
Well, let's move both.
The 9th?
Yes, how about Thursday, April 9th?
That would be great.
So when you work on a stip on Mr. Zablocki, let's go both of those to April 9th. All right, set a LPT Stands for last pretrial before jury for April 9, 2026 at 2:00.
Just for my own understanding, Your Honor, didn't you say that Thursday is regular pretrials and Friday morning?
No,
is
Thursday
final?
is the last pretrials. The attorney
Oh.
pretrials are the first Friday of each month.
I had it backwards.
That's when we have like 70 people here all at once, and
I switched it.
we got more time to
Okay.
deal with it on Thursday the 9th.
That sounds good.
Brandy, does that date work for you?
Yep. Okay.
All right, I don't know where this is headed. I'll just put this out here. There were some discussions about a no jail recommendation, and I'm not at this point willing to accept it. If you do enter a plea in my court, I'm gonna get a pre-sentence investigation. Frankly, I told your lawyer, I don't know what to do with you. And so at this point, you're still presumed to be innocent. And if we go to trial, that's okay too. But if you get convicted, I'm not gonna shoot from the hip. I'm gonna get some help from a probation department and a recommendation. So at this point, you're presumed to be not guilty on both cases. The cocaine charge is bound over to circuit court. I am concerned that you got charged with this while you were on that felony bond. So let me repeat, don't do any other things that bring you to attention of law enforcement. And the next time I see you, I'm probably gonna give you a drug test. So I want it to be clean. All right, thank you. You're all good to go.
Thanks, Judge.
Thank you, folks. Have a seat, please. This is file number 251441DO, and the matter is captioned Rose versus Grant. So it looks like we have Miss Morgan Rose this afternoon and Mr. Timothy Grant. Good afternoon, folks. Thanks for coming. Miss Rose, would you join me at the podium? And Mr. Grant, if you would rise, I'd like to administer an oath to both of you. If you would both raise your right hand with me, do you promise that you will tell the truth, the whole truth, nothing but the truth, so help you God?
I do.
All right, sir, you have a seat. Thank you very much. Miss Rose, you're at the podium, and you're going to answer most of the questions because you are the plaintiff. Do you understand?
Okay.
No, you're not getting picked on.
All right.
There's a judgment of divorce that's before me now, and as I look through it, I see signatures by both you and your husband. Did you read that document over carefully before you signed it?
Yes.
Yeah, it's important that you did, Ms. Rose, because when you sign it and the court approves it, you formed a legal binding contract with your soon-to-be ex-husband. Do you understand that?
Yes.
And you can't come back later and renegotiate or ask the court to change those terms. They're forever in binding. Do you understand that?
Yes.
You have any questions about any of that?
No.
Do you and Mr. Grant have in common any minor children?
No.
Are you pregnant?
No.
Has there been a breakdown of the marriage relationship to the extent that the objects of matrimony can no longer be achieved?
Yes.
Is there any reasonable likelihood of reconciliation?
No.
And is it true that you filed a complaint for divorce in this court on or about December 16th of the year 2025?
Yes.
And that on that date that you filed that complaint, had you lived in Shiawassee County for at least 10 days?
Yes.
Did you also live in the state of Michigan for at least 6 months before you filed that complaint for divorce?
Yes.
Do you have any questions?
No.
Are you gonna be okay?
Yes.
Okay. Mr. Grant, did you hear the questions I asked Ms. Rose?
Yes, I did.
Would you answer them any differently?
No.
Okay, are you gonna be all right?
Yeah.
All right, I'm glad to hear that. Good. The court does find then that there has been a breakdown of the marriage relationship to the extent that the objects of matrimony can no longer be achieved. There remains no reasonable likelihood of reconciliation. I've read over your judgment. I find its terms to be fair and reasonable. They're all approved. And I will sign it.
Well, that was quick.
Well, yeah, it's good, right?
Yeah.
So I have a question. Does that mean we don't have to come for the court date on the end of the month?
Not unless you want to.
Okay, no, I don't want to.
You
I
sure?
was just wondering.
You want to do jury duty instead?
No.
No? Okay.
I was just trying to make sure we got it all taken care of.
You're fine.
If I would have known it was going to be this quick, I'd have taken tomorrow off so I could celebrate. No offense. We don't hate each other. It's just done and over with because divorces obviously are stressful. You would know. So I was just like, no, I'm just going to go to work at midnight and put Pepsi or 7-Up on the shelf. And check it out.
One of the biggest stressors in your life is a divorce, right? It's huge.
Yeah, that sucked.
Yeah. Well, you guys will get through it. You seem like good people.
We try to be.
Yeah. I've signed your judgment. Sergeant Wells will give the original and the copies to you, Ms. Rose. Your next stop will be the clerk's office, which is the office directly below this courtroom. Head on down there. They'll process your copies and give you each a true copy of the judgment of divorce. Make sure you keep that where you keep your other important documents. You guys are all set. Take care of yourselves.
Thank you so much, Your Honor.
Yeah, you're welcome.
If I would have known it was going to be that easy and that fast, I would have taken tomorrow off so I could celebrate. My goodness. I mean, I've seen people who are happy about getting divorced, but that's kind of crazy. Anyway, what's going on here? Why can't I see chat? There you are. Oh, wrong way. There you are. Anyway. That's all I got. It's not all that happened today, but that's all I really put together for tonight. I absolutely had to watch the Tote case. I knew Mama Wolf was anxious to see that one, so I did not want to wait till Saturday, but there was more that happened in Simpson that is arguably a little bit more interesting. Talking about some crayons on the walls and stuff. We're going to be looking at that on Saturday, so just throwing that out there. Saturday is already shaping up to be a very interesting show. And possibly kind of long. Just throwing that out there, kids. Don't forget, like, comment, subscribe, all that type of good stuff. And if you do so inclined, come on by. Same Wolf time, same Wolf channel tomorrow, and every day following, for more live content just like this, for daily court calls. I try to find the best stuff from every day and get it put together for at least a little 2-hour block so we can all sit around and chat about some court stuff and try and make sure it's not the same stuff that everybody's been showing all day long. So come on by. Look at those sleepy puppies back there. Give them about 2 minutes. They're going to be up and begging to go outside. Ladies and gentlemen, I am your Lone Wolf Usul. I am your humble host for these here little get-togethers. I'm your curator here at the Court Gallery, and I will be back tomorrow. But for now, I am out. Oh yeah, don't forget. It is really rough weather out there tonight, so I want to make sure, my friends, that you stay weather aware. So, when you're not watching Hutch's stream that's coming up right next, and we are redirecting to it, make sure you tune in to Ryan Hall, y'all. Stay safe. Be weather aware. Don't forget, I gotta have you here to enjoy your presence. And never, ever underestimate the power of stupid people in large numbers.